welcome to today's panel as part of our launch series on the new Journal of Free Speech Law, which is brought to you by the UCLA Institute for Technology, Law and Policy, in collaboration between the UCLA School of Law and the Samuel School of Engineering, whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. My name is Michael Karanicolas. I'm the Executive Director for the Institute for Technology, Law and Policy. I'll begin by acknowledging UCLA's presence on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. And I want to allow as much time for our incredible speakers as possible, so I will be very brief in introducing them. Jack Balkin is a Knight Professor of Constitutional Law and the First Amendment at Yale Law School and the founder and director of Yale's Information Society Project. Mark Lemley is the William H. Newcomb Professor of Law at Stanford Law School and the director of the Stanford program in Law, Science, and Technology. And Daphne Keller directs the program on platform regulation at Stanford's Cyber Policy Center. And our wonderful moderator, Jane Bambauer, is visiting affiliated faculty here at the Institute of Technology, Law and Policy, as well as a professor of law at the University of Arizona. Jane, I turn it over to you.
Thank you, Michael. Well, and it's my pleasure to welcome Jack, Daphne, and Mark, as well as Eugene, of course, our great leader here at the Journal of Free Speech Law, to talk about their essays recently published in the Journal of Free Speech Law. I am posting in the chat right now a link to their that edition where you can get all of their essays. And this is the fifth in a public panel series, all of which we're going to eventually put together and put in one place. But these three essays, I think, really work well together. I'd love to start with just a 5 to 7 minute summary of what each of you have said. And then there's going to be a lot of overlapping themes, but not entire agreement on those themes. And so I think we're going to have a lively discussion. So Mark Lemley, do you want to go ahead and get us started?
Sure. So yeah, there's a lot of moving parts to this paper. So the 5 to 7 minute high level version is this. The paper is called The Contradictions of Platform Regulation. And the basic thesis is this: everyone wants to regulate big tech right now, wants to regulate platforms. But what I suggest is that they want to do it in radically different and often inconsistent ways, and that the apparent consensus for regulation turns out to be illusory when you get down to what it is people would actually do. In the paper, I walk through lots of examples of how the proposed regulations that are out there are, in some senses, crazy, in some senses, just sort of mutually inconsistent or pushing in opposite directions. I'll flag a couple of examples. So in the United States, everybody wants to do away with or reform Section 230 in Congress, which immunizes platforms from tort liability for content posted by another. But they want to replace it with completely inconsistent things. Democrats want to weaken Section 230 to force platforms to do more content moderation, to take down hate speech, disinformation, Donald Trump, and the like. Republicans want the opposite. Republicans want to require platforms to allow any content that's constitutionally permissible and to limit the ability of platforms to regulate on the basis of content. Those perspectives have different merits and demerits. I think they each have their own sets of problems, but they have a really significant contradiction, right? You can't do both of those things. And in fact, you can't even sort of push in one direction without upsetting the people who want you to push in the other direction. Other examples I think we see in many, although not all, of the antitrust efforts that are being brought against big tech, particularly those that are aimed at advertising markets. Part of the problem here is, I think, a contradiction or a tension in goals between wanting to break up data monopolies and introduce competition into the world and wanting to protect data privacy. One of the ways that we would get real competition between platforms is to introduce new companies, give an interoperability mandate that gave them access to the same information that the dominant firms already had. Doing that, though, probably means less privacy, more distribution of consumer data for everyone. Conversely, if you want to prevent the dissemination of data that's already out there, you are cementing the control that big tech already has, because you are cementing the advantage they have in information. We see other contradictions or tensions in cybersecurity. Governments want to stop data breaches and hacks, but they also want their own backdoors into people's accounts and to ban things like end-to-end encryption for political and law enforcement purposes. Doing that's going to weaken cybersecurity. We see this play out in various ways. The EU has both imposed a rule that you have to keep data and a rule that you must delete data. And so their solution to some of these contradictions is to adopt rules that kind of squish you in both directions. You've got to keep data for 6 months, but you can't keep data for longer than 24 months. We make you keep data so our law enforcement people can get a hold of you. We make you get rid of data so we can try to protect privacy. And then some of the regulatory proposals just sort of verge on the silly. My favorite example here involves algorithmic targeting of content. There's lots of agreement that algorithmic targeting of content is a bad thing. And so a number of people in Congress have merely proposed, well, you know what? Platforms should have to offer an algorithm-free experience. You can target content with an algorithm if you want to. Just give us a non-algorithmic version of Google or a non-algorithmic version of Facebook as well. Asked to imagine any aspect of the internet that didn't involve an algorithm or automated process, one expert quipped, quote, "I'm picturing a computer that is turned off," close quote. So what's going on here? I mean, I think some of what's going on here is people want different things. And recognizing that and that they can't all be accommodated in some senses should cause us to step back from the demand for regulation and say, hey, the question is not should we regulate big tech? The question has to be, what is it you want big tech to do and what is it you want the law to force them to do? And once you start asking that more specific question, some of the regulatory proposals, like the proposal to get rid of Section 230, start to make little sense, right? Because it's clear that the demand for change is really hiding fundamentally inconsistent and irreconcilable visions of what it is we want government to do. For others, the problem is not that you can't do these things at all, but that there are trade-offs and that we are not acknowledging the trade-offs, right? Demanding, an algorithm-free experience, demanding that we break up data monopolies are fine if you acknowledge that you're going to be doing harm to other things you care about. Right, that you're going to be doing harm to privacy, for instance. Demanding encryption or demanding the absence of encryption are fine as policy proposals as long as you understand that you're going to be doing harm to other things that you say that you care about. And so we either compromise doing something that doesn't fully achieve either goal, or we pick one goal, but we need to do so understanding that we are undermining other things that we say we care about. And then finally, and more broadly, I think the reason there are so many demands for regulation from all quarters is because of the outsized influence that tech companies have on our lives. They're private companies, but they don't feel like private companies as we interact with them. We don't feel like we have a good choice. Their rules often seem like kind of de facto governmental mandates. If I'm blocked from Facebook or Twitter and I don't feel like I have a cause of action or a recourse when I've been blocked improperly, that doesn't feel like I've got an open and competitive marketplace. While that provokes calls for regulation, I think what we ought to look towards instead is a market that's open to competition. Right? Regulation is going to entrench in place the dominant firms who can pay the armies of lawyers and policymakers to navigate those regulatory frameworks. It's going to say, we've got to live with Facebook as our social media, and now we'll try to sort of make it a somewhat better Facebook. We might instead want to say, let's have a competitive marketplace. Let's use interoperability. Let's encourage nascent competitors rather than having them be bought up and shut down by the dominant firms. And I think in the long run, we'd be better off looking for ways to try to restart the competitive process in big tech than we would be locking in incumbents as the only ones that can effectively comply with the morass of contradictory regulations that we will end up creating. And with that, I'll stop.
Perfect. Okay, Jack. So take us through your essay, which I think does some of the work of articulating which types of trade-offs seem most valuable. But I'll let you put it in your words.
Delighted to. So this follows on very nicely to Mark's essay. So this essay is called "How to Regulate and Not Regulate Social Media." And if you want to regulate, you have to know why you want to regulate. So right now, of course, you have lots of people who not only want to regulate big tech, they actually want to change basic doctrines of First Amendment law to deal with harmful speech and false speech. And my view is that that's not really what the central issue is. The reason you want to regulate is because you're concerned about the health and vibrancy of the digital public sphere. Well, how do you know whether the digital public sphere is healthy and vibrant? Well, the answer is, it turns out whether or not it protects the values we generally associate with freedom of expression. That is the values of political democracy, what I call cultural democracy, and the growth and spread of knowledge. So what we really have to think about is how should we organize these industries so as to promote the values of a healthy public sphere. And so the real question is industrial organization. The industrial organization of digital media and the current business models of social media companies. Now, right now, a point that Mark made, only a relatively small number of social media companies currently dominate online discourse. And in addition, their business models, which are based on the accumulation and exploitation of consumer data, give them a lot of bad incentives to act irresponsibly and to amplify false and harmful content, not only in the United States, but around the world. And in fact, the companies mostly care about what happens in the United States. They care very little about the effects of their business practices the rest of the world, because the rest of the world doesn't have enough power to basically give them any trouble. So given the fact that what we're looking for is a well-functioning public sphere, the goals of social media regulation should be twofold. And this is going to hark back to the point that Mark made. They're plural goals, they're not one goal. And these goals are partly in tension, and I'm going to talk about how you might resolve them. The first goal is media pluralism. That is, there should be a much more diverse ecology of social media companies so that no single company's construction of the digital public sphere or governance of the digital public sphere dominates. So that's the goal of pluralism. The second goal is to give social media companies, or at least the largest and most powerful ones, some incentives to become trusted and trustworthy organizations for doing what social media companies are supposed to do, which is facilitate, organize, and curate public discourse. Let me pause for a second and talk about this tension. So if you want trusted and trustworthy organizations, not all of the organizations you create are going to be equally trusted and trustworthy. So what we want really is as many as possible. We want a lot of different organizations with lots of different kinds of affordances, lots of different things they offer, lots of different rules and rule sets, to go back to a very old idea in cyberspace law. But we want to make sure that the largest and most powerful ones, the ones with the greatest degree of control over public discourse, have incentives to be trusted and trustworthy. So what we are recognizing is, in this world, there will be lots of social media companies that won't be very trustworthy and won't, in fact, be very well behaved. But we just want to make sure there are lots of them, and we want to make sure that the biggest ones are trustworthy. Well, how do we do that? And here again, this is going to follow on the points that Mark made. First point is, there are basically three levers you have to do this. One is competition law, which is much broader than antitrust law. The second is consumer protection and privacy law. And the third is telecom policy, which is basically what people are talking about when they talk about Section 230. My general view is that the most important reforms have to be in competition law and in consumer protection and privacy law. In competition law, much of what I'm going to say is just follows on what Mark said. You might want to have policies that create many, many more firms with lots of different innovations. You might want to prevent mergers that buy up firms, by larger firms buying up smaller firms, and thus stifling innovation. You might want to break up different functions so that you are not the largest ad broker as well as the largest social media company. And finally, a point that Mark made, you might want to have interoperability rules that basically allow the creation of applications that allow people to access multiple social media at once and to freely exchange content between them. Those are all things you would want from the standpoint of competition law. But they all create privacy problems for the reasons that Mark articulated. And so you also need privacy and consumer protection reforms. And those reforms can't simply be limited to the largest companies. They have to apply generally. In fact, what we really need is we need comprehensive digital privacy law in the United States, something that we don't have here, but you have in Europe and other countries. I'm not saying that we should adopt the same as we have in Europe, but that we need one. If you are going to have competition, if you are going to have multiple firms with multiple affordances, you really have to spend a lot of time thinking about how you're going to provide consumer protection and privacy, because antitrust without privacy regulation basically can make things worse. And similarly, as Mark pointed out, privacy regulation without paying any attention to the competition policy issues will basically throw in the towel on the problems of monopoly, which is basically what we're facing today. And what's the third lever? Well, the third lever is telecom policy. And here, I tend to not think that Section 230 needs very much reform. I mean, there are some things I do around the margins, but what I would actually do is I would use Section 230 at least with respect to social media companies, but not many other digital businesses. Remember, Section 230 is relevant to lots and lots and lots of digital businesses. But I would use Section 230 as a kind of regulatory lever. That is to say, if you're a social media company and if you want Section 230 immunity, we're going to ask some things of you in return. And this would be a 21st century version, although please don't worry, I don't want to import the entire 20th century apparatus. It would be a 21st century version of the idea of a public trust, or the idea of a public trustee idea, where in fact, in exchange for a valuable regulatory subsidy, we ask the largest companies to act in some ways in the public interest. And that might be tied to particular kinds of privacy regulations, to making certain kinds of algorithms that are used opened up to ombudsmen, so that in fact you can have inspection of them. Also having to do with the composition of their labor force. In other words, once you imagine the possibility of such a bargain between Section 230 immunity for social media companies and the immunity, then you can imagine a bunch of things that might in fact be in the public interest. And the last one, of course, is a point that's been made before, which is that you might require some degree of disclosure or transparency with respect to the operations of the very largest companies. How far down in size you would go, I think, is an important and interesting policy question, because the more regulations you pile on companies, especially the smaller ones, the more there is the danger that you won't get enough companies. And as I said before, pluralism is an extremely important value here. Thank you very much.
Thank you. All right, Daphne, will you take us through your essay?
Yeah, so I want to start by strongly seconding part of Jack's point, which also built on what Mark was saying, that a lot of the best ways forward here lie through competition or through privacy or consumer protection, rather than through sort of top-down regulation of online content and information. That, even though most of my article until the very end isn't about that, that is the actionable upshot. And I like to think that the bulk of my paper, which instead is about First Amendment barriers to regulating amplification of harmful content, the bulk of that is about what I like to think of as useful negativity, like saying there are a bunch of dead ends over here, you guys, so channel your energies over there to attack the same problems through privacy and competition. So I just want to kind of put that out there at the beginning, and then I'm going to talk First Amendment doctrine for the remainder of my time, I think. This paper, like so many things that I write, comes from a place of frustration with people being wrong on the internet. And There are people on the internet who keep saying that we can regulate the reach of harmful content, and that doesn't count as regulating speech. So if Congress just did that, it can dodge First Amendment problems. Or if regulators in other countries just did that, they could bypass the restrictions of the speech protections and First Amendment analogs in other legal systems. And that's just not the case. We won't solve any of our problems with harmful content by telling platforms to demote certain user speech, because it runs into the same problems that we have when we tell platforms to delete certain user speech. In practice, demands to fix the algorithms and demote certain speech run into the same problems that we see in discussions about amending CDA 230 and putting new obligations on platforms to face direct liability for the speech itself. This is not to say, I'll get to the sort of constitutional arguments in a moment. This is not to say that companies can't use demotion or changes in ranking algorithms for news feeds or for search results or for recommendations. This isn't saying companies shouldn't work on that. They absolutely should, and most of them are. They have a lot of ability to change what kinds of content people are seeing, including reducing exposure to speech that might incentivize violence, for example, by changing their ranking and recommendation algorithms. But if we shift from talking about what companies themselves to do to talking about what Congress can mandate, we run into a bunch of First Amendment problems. There are two varieties of First Amendment problems. One is about the speech rights of internet users. So we have a class of potential objections to laws that would be raised by users as plaintiffs. And the second is about the speech rights of platforms themselves. We have a class of constitutional objections that would be raised in hypothetical litigation by platforms as plaintiffs saying, hey, this law violates our rights. In fact, these are not hypothetical because they're the same arguments platforms are raising in objections to laws in Texas and Florida right now. The user part is that if the government requires platforms to suppress lawful speech, obviously that could violate users' First Amendment rights. Even if it just incentivizes platforms to suppress lawful speech, that too can raise problems for internet users. I'm one of the outside counsel in a case called Woodhull, which is a challenge to a CDA 230 amendment from a couple of years ago. And the DC Circuit confirmed, yes, internet users can challenge laws that incentivize platforms to silence them. This isn't surprising if you've read old bookstore cases like Bantam Books, which gave publishers standing to challenge, successfully challenge in that case, government action that formally was just regulating bookstores, that was causing bookstores to silence their speech. This is something that obviously implicates the bookstores' rights, the intermediaries' rights, and also the rights of book writers and readers. So anything that causes platforms to delete or demote users' speech potentially raises First Amendment issues that would be brought by them in a case. The other side of it is the platform's own arguments saying, hey, we have editorial rights to decide on our ranking policy, just as we have editorial rights to decide on our content moderation policy and which kinds of user speech we do and do not permit here. Therefore, we platforms have a First Amendment objection to any law that regulates the algorithmic ranking of content on the platform. This is something that variants on this argument have been raised pretty successfully, consistently successfully in lower court cases by platforms. I've written about this in detail in an earlier article called Who Do You Sue? Eugene has also written about it quite a bit. Whatever you think of ultimately, what the Supreme Court should do with this question when and if it gets there, it is unambiguously the case that platforms have a strong argument to be made based on their own rights. And so any law would have to navigate that. So in the paper, I go through 3 potential models for laws telling platforms to stop amplifying harmful speech, telling them to change the algorithmic ranking of speech. And I look at the objections that either users based on their First Amendment rights or platforms based on their First Amendment rights might raise to each of these models. First, I talk about a law that on its face just tells platforms to demote illegal speech or stop promoting illegal speech or strips immunity away from them for illegal speech that is amplified, that appears in a ranking newsfeed, et cetera. And there, the problems, most of the problems are the ones I've just described, the sort of how, sorry, let me back up a little bit. The biggest problems that I see come first from the incentives that such laws would create for platforms to overdo it and take down lawful speech. These are the same problems that we see in any discussion of platform speech regulation. There's nothing unique about the amplification context. You know, we would foreseeably have to navigate problems with platforms taking down any speech that is accused of being illegal or taking down categories of speech, much as we've seen platforms take down, you know, erotica categories on Tumblr for fear of liability, or dating categories on Craigslist for fear of liability. Those problems that we are familiar with from the ordinary intermediary liability context just recur if things get kicked out of the news feed and the ranked part of the platform that is sort of the most useful real estate where users want to be seen and heard. Another way of looking at that is to say, if we thought platforms could accurately identify which speech is illegal, that we could make a law that would incentivize them to do just the right thing and take down the illegal speech and not overdo it and also take down the legal speech, then why would we screw around and just make them liable for amplified content? At that point, we might as well make them take down the illegal content, if we have faith that they can correctly make this choice. As a doctrinal matter, a key line of cases here include the Playboy case and other Supreme Court cases in which the court has said, when the government sets out to burden speech to merely make it harder to distribute, that faces the exact same level of strict scrutiny as when the government sets out to ban speech entirely. So if we move the usual discussions about platforms overdoing it and silencing user speech out of the must you delete it context and into the must you demote it or stop amplifying it context, you don't reduce the constitutional scrutiny. You face the same First Amendment barriers that many of us are familiar with in other areas. I have run out more than my time, so I am not going to expand on the other two models, which are the idea of telling platforms to restrict amplification of legal but harmful speech. We've seen proposals like this in the UK. And then the idea of having content neutral restrictions on amplification. But I will come back to my starting point, which is that I think if we tried to regulate amplification in a different way, through competition and trying to increase the number of different ranking algorithms that we have to choose from, or through privacy laws that give users the right to control how their data is used to rank content in their newsfeed, we could actually get to some very productive outcomes that avoid these First Amendment challenges. And so I hope we can spend some time talking about that. Thank you. Great,
thank you, Daphne. Okay, so I know we have a lot of participants, and I will get to their Q&A quickly. By the way, for those in the audience, feel free to write the letter Q or something like that in the chat, so I know to call on you if you'd like. But I do have a question, and I also want to allow you guys to sort of circle back to each other to see how you might react to various things. So Going to Jack's vision of what we're trying to achieve, I think I certainly personally agree with it. I suspect most of us do, that we want this, as he put, cultural democracy, where we have pluralistic media, but the center of gravity of that ecosystem is somewhere that has some norms of, being tethered to facts and having some integrity. I don't understand, though, how privacy or even sort of competition helps us get there. So sticking with competition for a second, it seems to me that what happened in the internet age is that greater choice and access to all sorts of different media has put a wedge between media that's trusted and media that's trustworthy. And without the bottlenecks of the old media, it seems like it's going to be quite hard to get the incentives right, where people will trust that the media that we all think is the best is the stuff that they should turn to. And so I worry somewhat that more competition actually means that there's more competition for engagement. That engagement does not correlate well with trustworthiness. And the same could be said with privacy as well, that if you can't have a sort of general interest news story that gets funded through behavioral advertising, then that means that, if you can only do contextual advertising, then you go to the context that engages more people, and that sort of seems to run toward the same problem. So I guess, Jack, maybe it's most directed toward you, but I guess I want to know whether Daphne and Mark see the same tensions that I do, and how those might be squared.
Yeah, I mean, one of the things is you shouldn't assume that antitrust and competition law are the central way to achieve a more trustworthy digital ecosystem. That's not its central goal. I mean, at the margins, there are some effects. Here's an example, but I don't want to put too much weight on it. If you have a very, very large number of different players instead of a relatively small number of players, it's much more difficult for some bad players who basically thrive off getting funded from high engagement but low information propaganda and what's called fake news stuff, who don't have to spend very much money to produce it, to basically get rewards, because they can basically game the system they learn how to game the system of the algorithms of a very few but very powerful companies. So this puts other sources of information at a disadvantage with respect to them. Once you increase the number of players, it's much harder for them to game the system the same way. But that's not a sufficient answer to the point. In general, you look to antitrust and competition law for the benefits of pluralism. You look to privacy and consumer protection law for the benefits of producing trustworthy business practices. So the question you want to ask is, how would privacy and consumer protection law make businesses more trustworthy? Well, it would not make them completely trustworthy. Obviously, they'd still be in the job of getting engagement and increasing their audience share. So they'd just be like 20th century media, who are always involved in engagement and getting new share, right? So, but that can be consistent with a relatively responsible attitude toward your duties toward the public. And the way you would do it is you would limit the ways in which data can be collected and which data can be used. And when you limit the ways in which data can be collected and data can be used, then what happens is certain kinds of incentives you have to make the extra buck by causing this kind of harm or that kind of social problem go away. You don't have those same incentives. It's not that you don't have incentives to make money, because you always will. It's rather that if you look, for example, I'll just take an example, at the various exposés that have come out in the Wall Street Journal and other places about bad things or not public spirited things that Facebook has done, you can see that in almost every case, they're because they want to maximize the value they get out of the collection and use of data. So if you change their incentives with respect to how they collect and use data, you will have, I think, some effects on the ways in which they approach their public. And what we want them to do, above all, is we want them to regard their end users as their customers, as opposed to simply their advertisers as their customers. We want to shift their focus of attention through privacy and consumer protection law.
So let me jump in on this. This is obviously it's a big and a really complex question and a problem. And I think you're right to say, right, competition and it isn't necessarily going to get us kind of better content in the sense of more truthful content. I do think that it relieves a lot of the pressure that comes from having a single choke point make decisions, particularly where that choke point is a private actor. I also think, and Michael notes this in the comments, right? And my paper called The Splinternet is in some sense about this. I think one of the things that it does is it, if you take this outside the United States context, pluralistic vision of lots of information sources is a harder thing for repressive governments to control and regulate than a centralized media is. And that is an important fact. It's a less important fact to date in the United States, although that might not continue to be true. But it is a very important fact throughout the world. But I think one thing that's worth keeping in mind is that there are a lot of values that are served other than the sort of values of getting accurate information to people by market competition, right? And some of those values are innovation in the way we actually get at or share information. And those potential innovations, which a single monopoly firm has much less incentive to create, right, may themselves open the possibility space, allowing us kind of new ways around this. The sort of kind of final point I'll note is, you know, there is a nostalgia, and I share this nostalgia to some extent, for a world in which the media sources that people turned to largely had some set of standards that bore some relationship to the truth. I think we are worse off for a world in which kind of misinformation proliferates. And I do think that's one of the things that drives a lot of demands to regulate social media, to regulate big tech. But the biggest problem with disinformation is not Facebook, it's not social media, it's Fox News, right? And I think it is extremely unlikely, right, that any of the regulatory proposals, if you took them and said, well, let's make sure Fox News is included in this because we know they are a source of consistent disinformation that is unwilling to change it once it has been identified as disinformation. Let's make sure they're subject to the same regulations. My guess is everybody would jump back and recoil in horror at an obvious violation of the First Amendment. Part of what's going on here is the tech is new, the tech is different, and that feels like maybe we can just apply different rules to it.
Right, and Fox News, though, may have been its own creature of increased competition through cable news, right? Cable access to cable channels. Daphne, do you have any comments?
Yeah, so I mean, I would say that I'm looking to both privacy and competition law here as levers to give individual consumers or users more power over their online experience and to diversify the experiences being offered to them, and hopefully also the entities, you know, making those offerings. And so I think that's kind of a normal thing to say about competition, and maybe a less normal thing to say about privacy. But you know, I'm thinking of rights for users to say how their data will be used, like more granular and stronger and more enforceable rights as a mechanism of getting to something more like, you know, what my Stanford colleague Francis Fukuyama has called middleware, for example. You know, just ways of opting into different content moderation systems, different ranking systems, different discursive universes to participate in. And so I think it, you know, as a matter of technical privacy law, that doesn't mean banning targeted advertising necessarily. Like there's a whole separate argument about what privacy changes should be made, but I'm not trying to get to that kind of a specific outcome, you know, as part of this paper at least. Zooming out from there, from the sort of how we use the legal doctrines to the big picture, the biggest objection that I see, or the most like fundamental objection that I see to the idea of diversifying what ranking systems or, you know, what content moderation systems, et cetera, users can opt into, is that it will just exacerbate echo chambers. You know, there will be people who choose the all lies all the time, or all hate all the time, or, you know, whatever platform or ranking system, or, you know, whatever the new thing is that they can opt into. And I think that's a really, you know, very legitimate concern, but it kind of comes down to this almost like Weberian question, or John Stuart Millsian question, or, you know, something about how you think about power. Like, are you happy having this incredible choke point on public discussion that we have from a very small number of companies now, because you think you can foresee a like legal and political and socioeconomic future where they use that power wisely? You know, where they're going to suppress enough of the harmful stuff that you're okay having them, you know, on that wall? Or are you a pessimist and you think that having any consolidation of power like that is, you know, a loaded gun waiting to go off as bad people come to power within platforms, or as bad governments gain leverage over platforms and, you know, cause them to make global changes to their speech policies, et cetera. And I think I'm just more in that pessimist camp, where I think that degree of concentrated power over global discourse is really scary. And I would rather take door number 2, where you risk having the echo chambers, than stick with door number 1.
Yeah. Yeah, it's I mean, maybe another way of sort of characterizing the problem is that with distributed media and information, the problems are also distributed, because the autonomy that I think many of your proposals kind of give to each user also gives them the autonomy to stay in echo chambers if that's what they choose to do. Okay, so audience, I invite you please to either ask questions or put Q in the chat. Do any of you have questions for each other?
So one of the ones that's in chat from Evan Goldberg, I thought I'd want to take on, right? So is it realistic to expect a small player to actually come compete against these behemoths, right? Which are bigger than many countries? And it's a great question. And I think the answer historically is yes, absolutely. Right. And again throughout history, we see this process in which kind of dominant firms get displaced by startups that weren't even there 5 or 10 years before. What's changed in the last, that process has sort of driven the technological world for decades, but it's stalled in the last 15 years. I think one of the things that's changed is that the companies that sort of are positioning themselves to be in that circumstance are now not staying in business, having IPOs, becoming big competitive threats. They are cashing out not by IPO, but by merger. And they're cashing out almost invariably by being acquired by the very companies who they would otherwise be a potential threat to. Right, so not just the sort of next Facebook, next Google direct competitor, but the adjacencies, right? The companies that would sort of build something new that could actually just sort of make that that dominant player irrelevant, right? Or just less important, as happened to Microsoft with respect to the internet, right? Those things, those companies aren't around anymore because they're getting bought up and either sort of integrated into the behemoth or shut down entirely. And so I think one thing that we can do to try to push competition, short of break up big tech, right, which I have some problems with, is encourage that nascent competition, bring back the sort of Schumpeterian competition and disruption that brings in waves of new technologies and new ideas that may displace the old or may just kind of render them irrelevant.
Just ask you this, Mark. You said that you have some discomfort about breaking up big tech companies, but I want to distinguish between horizontal and vertical. Do you have any problems with disaggregating the different functions that Google and Facebook currently serve?
I mean, so I think part of the problem is it's hard. I would put, if the choice is sort of chop them into pieces, there are some ways I think you could do that and do relatively little harm. There are lots of ways in which you, I think, couldn't do that without sort of doing substantial harm. And it may be that.
So let me give you an example.
Okay.
Right now, as you well know, Google and Facebook are two of the largest ad brokers in the world. They're also, and so they're buying and selling advertisements. They're in competition with companies who are also who are basically also advertising or having advertisements placed on their sites. So in sort of standard antitrust theory, this is a problem. That is to say, the platform is competing with the people who are participating on the platform. Would that be a disastrous idea to basically say, look, you can be in this business, but you can't be in that business. You can't be in the ad brokering business, but you can be in this other business. Or similarly, Facebook wants to get into, wants to be a bank, right? It's been wanting to be a bank for many years. Imagine we said, you can be a social media company, you can't also be a bank.
Yeah, so all right, so I think those are great examples because I think they might push in different directions, right? So where you are vertically integrated and you are in a position where you will have to be self-dealing, we definitely have problems. If you are a vertically integrated monopoly who has to self-deal, right, then we might think about a non-discrimination mandate, right? So Europe has talked about kind of a sort of no preferencing rule for Google search results, for instance. Or we might think about a structural separation. I think one of the problems, one of the reasons that Google is in the sort of ad broker business is, right, that many of these start out as ads placed on Google itself. It seems hard to say that should be something Google's not allowed to do, right? So you're doing already a bit of an artificial separation between third-party placements and placements on Google, but it might be feasible, might be workable.
Yeah, here's another example. One of the reasons why Google gives away so many things for free is that they're all devices by which you can collect more and more data.
Well, that's I think what the problem is with breaking up the two functions, right?
Well, right. So that's where we're going to go. And one of the things I talk about in the paper is, right, I think, from an antitrust perspective, we might want to say, yeah, these things all ought to be separate, right? But if we want them to be separate and we want the market to be efficient, right, what we're saying in effect is lots more people should have access to all of this information about you, right?
Well, even
so
if they have access, there's a question as to whether and what they can do with the access. So don't confuse access with use. Don't confuse collection with use. Those are two different ideas in privacy law.
But if you want to take that perspective, right, then what you got to say is we're gonna have we're gonna break you up. We're gonna have a bunch of separate companies here, a bunch of individual advertisers, and we're going to impose a detailed regulatory structure on every one of you, right? Not just on the one platform, right, but on everybody, right? So all of your costs are going to go up. I'm not saying you can't do it. I'm saying there are a bunch of costs and a bunch of arguments, right, that are at odds with each other here.
Wait, so I want to make sure I understand though, Jack. So Google would do all of its free services, collect the data, and then be a data broker, but not in the ad placement business. Is that what you're suggesting?
I'm not sure it should be allowed to be a data broker either.
Well, then why does it provide the free services? Why does it do that?
It uses it in order to advertise on its own site and its own products.
But that's not nearly.
What do you mean its own products? It can't have any products, right? We're saying
it advertises. It makes
on its
money
services.
Selling advertises that appear on its own product.
Okay, but that's not nearly the same revenue size of the same. That's not the same revenue size that it has right now. So the services necessarily will be different, less.
Yes,
right?
I think you're starting to get the light here. That is to say, as you change the basic economy in which the person who collects the most data wins, which is the current economy of the algorithmic society, as you change that into a situation in which the person who gets the most data does not win, then you get a reorientation of industry structure. you get, and it encourages, I think, the Schumpeterian kinds of issues that Mark was raising. The reason we have the kind of monopolies we have is because we live in a political economy in which the company who gathers the most data wins. That is the source of most of our problems.
I mean, I'm curious what Daphne thinks. I think that consumers hugely benefit from services drawing them toward it and giving their data as their sort of payment. And if you cut off much of that ability to take the data and monetize it, then the services that are offered, at least the services that are offered for free, are going to be much less valuable, or at least I fear that that's what would wind up happening. Daphne, oh, you're muted.
So I don't understand what happens in this world. Is that we have lots of little players providing pieces of the service that's provided by a single company now. So there's an ad company and like a Gmail company and a search company, or whatever. And each of them has some data that they've gathered that they can use at their point in the chain, but they don't pass the data to each other. In which case we've sort of optimized for privacy protection, but forfeited, as Jane was pointing to, the sort of things that are useful about data-driven services. Or is it that they can all collect different pieces of data, but then share them with each other? And then we have the problem that Mark was pointing to, that I think Mark was pointing to, of like, any fly-by-night entity in this new multi-party system can be the point of failure. That's a giant data breach for everyone. So is it that we are basically giving up on data-driven services because we think that their harms outweigh their benefits, and that's just the trade-off we're accepting, or is it something else?
Well, it could be a little bit of both. In other words, imagine, let's go back to, remember Cambridge Analytica?
Mm-hmm.
That was a whole scandal where basically Facebook allowed a fly-by-night organization to have access to the social graph. All right.
Yes.
I assume you think that was not a good thing. If you think it was a good thing because it increases the number of services, well, that's fine. We'll go off in that direction. If you think it's a bad thing, then you might ask, well, how would you regulate data collection and use and distribution so as to avoid the bad thing? And the answer—
I mean, this is in the bucket Mark talked about, where there is a trade-off and we need to spell it out and make the trade-off. And it's gonna be a compromise between privacy goals and competition goals, and like that's unavoidable, and we should start talking about it.
Let me
50 minutes. We've gone 50 minutes, and I haven't said information fiduciary yet. So I now will say it.
Someone did in the let's see, Evan did in the chat, so don't worry, it's in there.
So let me make one specific point about Daphne's point there, though, right? Which is right. If you want to say, if you want to regulate and say a Cambridge Analytica is not an acceptable use, right? That's something you can do relatively straightforwardly, maybe constitutionally, maybe not, right? In a world where Facebook is everything. It is not something you can do easily if the answer is Facebook has been sort of chopped from all of the services that will be attached and must have open APIs, right? Which is great in many respects, right? We would get a lot of benefits out of that, but one of the things we would lose is the ability to do that kind of centralized regulation or control.
Well, okay, so I have a question for you, Mark. Are you telling me that if we had health records that are available to many, many doctors, that you can impose HIPAA on all of them?
No, of course not. But if you're, but if you impose HIPAA, right, on every doctor, you create a whole bunch of compliance costs on a bunch of small entities.
Also, doctors do charge more than Google.
Also, at best, you're getting after the fact remedies where you can sue the fly-by-night company that's not in your jurisdiction that has just spread all your data all over the internet.
Right, but so I think we're getting near the end of the hour, but I think collectively we basically see what the trade-off is. You can have ex ante compliance restrictions on data sharing, but if you have ex ante restrictions on data sharing and use, then what you're going to have is certain kinds of business models are not going to be viable. You'll have a different structure of industries. If you say no, we're not going to have ex ante collection, use, distribution restrictions, we're going to, let the chips fall where they may, you'll get a very different industry structure. But I would predict it's an industry structure that, in fact, is going to abuse the trust of lots and lots of people, and not only in the United States, but around the world, since data that's collected from different countries can then be used in order to benefit populations in America and Europe. So if you're worried about questions of justice, an important question, it seems to me, you have to say, what is the kind of industry structure you want?
Well,
Right.
all right, yeah, okay, right, but again, I think it's a little more complicated than that, right? So, what do you mean by justice? If you're a Republican in Congress, what you mean is I shouldn't be kicked off a platform for engaging in hate speech. That might be justice, it might not be justice. Different reasonable people can differ. But the structure of whether or not we've got a group of competitive people providing information or one central choke point is going to affect dramatically, right? Both the impact if you are kicked off, the incentive to try to regulate and determine whether or not you will be kicked off.
Well, this has been fun and invigorating as I anticipated it would be. I want to let the audience know that we are going to have another public panel, sort of like this one, but on topics related to freedom of thought, based on an essay written by Jordan Wallace Wolf in the Journal of Free Speech Law, and that will be this Friday at noon, same Zoom link. So keep it in your, I don't know, keep it in your cut and paste, I guess. I can't thank enough Jack Balkin, Daphne Keller, and Mark Lemley. Thanks so much for joining us.
Thanks, everybody.